a session of the Commission on Narcotic Drugs. And this side event is co-sponsored by the government of Australia, Austria, Mexico, New Zealand, the United Kingdom, the European Union, as well as the OHCHR and the Pompidou Group. So many thanks for the co-sponsors for sponsoring this event. I would like to first mention that HRI stands in solidarity with the Ukrainian people, and we urge the government and international community to use their power to ensure the humanitarian corridors inside Ukraine. Moving on, this webinar is carried out to specifically discuss the death penalty in the context of drug policy. For more than a decade, Harm Reduction International has consistently monitored the use of the death penalty for drug offense and advocate towards its abolition. And earlier this week, on Monday, we launched the Global Overview 2021, which I'll share with you on the chat box later. Please be informed that there is Bahasa Indonesia to English simultaneous interpretation. If you need it, don't forget to click Bahasa Indonesia or English on the language interpreter icon at the bottom of your screen. And finally, do let us know on the chat box if there is any technical issue with the webinar. Please post as many questions as you want on the Q&A box. And before I introduce the moderator for today's webinar and hand over to him, I will play a pre-recorded opening remarks from Mr. Felipe Gonzales Morales, the UN Special Rapporteur on the Human Rights of Migrants.
Thanks for the invitation to participate at this side event about the death penalty for drug offenses and its impact on foreign nationals. As the United Nations Special Rapporteur on the Human Rights of Migrants, I have had to address repeatedly this issue. I have sent communications to a number of states regarding foreign nationals who are confronting the death penalty as a result of drug offenses. There is indeed a disproportionate impact on foreign nationals in the application of the death penalty due to drug offenses. And there is an issue of lack of proportionality of the death penalty itself, especially when it is applied to cases of drug offenses. This is aggravated in the case of foreign nationals who may not be aware of the existence of the death penalty for drug offenses. An issue of major concern in many of these cases is the flaws regarding due process guarantees. This is generally problematic for death penalty cases in all countries that apply this penalty. But it is much more problematic regarding foreign nationals. And this is the consequence of serious flaws that, for instance, legal representation, access to justice, represent for migrants. This is an issue that my mandate has repeatedly addressed, and it is included a report to the United Nations General Assembly about the issue of access to justice for migrants. In regard to the death penalty, this becomes especially acute. It is indispensable that migrants or foreign nationals have an adequate legal representation able to challenge the accusations when the death penalty is involved. The other issue concerning also due process guarantees is the need for a strong participation by the consulates. That is the issue of consular assistance. If this consular assistance doesn't come at the right time, this may severely harm the defendant. And unfortunately, this is the case in many situations. As I mentioned at the beginning of my presentation, I have sent communications to a number of states regarding specific cases of foreign nationals who are about to be executed due to drug offenses. It is indispensable that states take seriously such requests, which come from the special procedures of the Human Rights Council, in order to not execute these persons. Thank you very much.
So now I would like to hand over to Zaved Mahmood, our dearest colleague from the Office of High Commissioner on Human Rights. He is the Human Rights and Drug Policy Advisor at OHCHR. And I wish you all a fruitful discussion during this webinar. Zaved, over to you.
Thank you, Azam. Good afternoon, good morning, and maybe good evening to all of you who joined this side event from all over the world. And first of all, I would like to congratulate the Harm Reduction International to organizing this event with other partners, as well as to make publishing the landmark report which came out this week on the death penalty and drug policy. Let me first introduce our speakers here. Today we have Giada Girelli. She's Senior Analyst of the Harm Reduction International. And she will be speaking about this, the new report. After that, we will have Mr. Tony Ojukwu, Executive Secretary, National Human Rights Commission of Nigeria. And then we have Tiasri Wiandani, Commissioner, National Commission on Violence Against Women, Indonesia. And then Sarah Farrukh from Justice Project, Pakistan. I know that our colleague, they will be putting all the short bio of the speakers on the chat room. Please, you may wish to look at it. Before I invite Giada for her remarks and making presentation on the new report, I would like to make few remarks about death penalty, also in particular with regard to drug related issues. At the onset, I would like to make very clear that the United Nations opposes death penalty for all crimes. We know the Secretary General in his remarks many times mentioned death penalty doesn't have place in this 21st century. Despite we know that death penalty being used and people being executed many places in the world on regular basis. Just few days back in one country in the North Africa, one day, 81 people being executed, and few of them, or many of them, we don't know the exact number for drug-related offenses. In another country in the Middle East, just large number of people being executed, including for drug offenses and terrorism and other of political offenses, which does not even comply with the international human rights law. Our office has recently issued press statement and condemned those execution. And the report which has been published day before yesterday with regard to death penalty and drug offenses is very alarming and very grim report, in a sense that the execution number, the way it has been increased. I don't want to provide you the data or information on this issue. Giada is going to speak on that. At the end, I would like to mention there has been several UN resolution from the General Assembly on moratorium, and also UN Human Rights Council resolution which addressed the issue of use of death penalty against foreign nationals and the vulnerability they face during the fair trial, during the trial process or investigation process, as mentioned by Special Rapporteur on Migrants. With that note, I think today we are focusing the discussion on the migrants' latest development and also on the impact on foreign nationals. I would like to hand over the floor to Giada. Giada, over to you.
Thank you, Zaved. And I share my screen quickly so you can see my presentation. So thank you again, Excellencies, colleagues. Thank you for joining this side event this morning. In the next few minutes, I'll walk you through some of the key findings of HRI's report on the death penalty for drug offences, which was released on Monday, and it's our 11th report on the subject. Before doing that, however, I want to take a second to express solidarity with the people of Ukraine and all those impacted by the conflict in Ukraine and in neighboring countries. I reiterate calls made to member states and UN agencies, including UNODC, to cooperate to ensure the continued provision of health services and health supplies, including harm reduction services, to all who need them in the community and in detention without discrimination. Now moving to the topic of today's discussion. In 2021, HRI confirmed that 35 countries retained the death penalty for drug offences in their domestic legislation, and this is despite this form of punishment contravening both international human rights and international drug control standards. And in the years, this was reiterated by, as Zaved was mentioning, OHCHR, the Human Rights Council, UNODC, and the INCB, among others. In 2021, however, only a minority of these countries actually executed people for drug offenses. We could confirm executions took place in 2 countries, meaning China and Iran. And we believe, based on trends, that executions also were carried out in other 2 countries, meaning Vietnam and North Korea. However, because of lack of transparency and censorship on the phenomenon, we couldn't confirm this information. Globally, 131 executions for drug offenses were verified, excluding figures from China. And again, because of lack of transparency and failure by the authorities to provide information on their use of capital punishment, this figure is to be taken not as a realistic representation of the phenomenon, but rather as representing a fraction of all actual executions that took place around the world. And this, unfortunately, is true for all the other figures that I presented that are included in the report. Now, zooming in on relevant developments. The first notable development was witnessed in Iran, where the Abdurrahman Burman Center for Human Rights in Iran confirmed 131 executions for drug offenses in 2021. And this is a stunning 424% increase from 2020, which goes against a mere 28% increase in total executions. Also, drug offenses were responsible for almost half of all executions that we could confirm in the countries, pointing to sort of a reversal of the trend that we saw in previous years. Worryingly, we also saw attempts to reinstate or introduce the death penalty for drug offenses in the Philippines and in Tonga. As of now, these attempts have not been successful. However, both these developments and the developments in Iran remind us that the death penalty is inherently political, and that we should approach abolition not as much as an end goal in itself, but rather as a milestone in broader drug policy and criminal justice reform processes. Other notable developments were in Saudi Arabia and in Singapore. In Saudi Arabia, no drug-related executions took place in 2021 for the first time in over 15 years. This is most likely due to a moratorium on drug-related executions announced by Prince bin Salman in early 2020. It's a moratorium that, however, has not been formalized or legalized in any way. And so until that happens, people on death row for drug offenses in the country are still to be considered at imminent risk of execution. And the mass execution of 81 people on 12th March remind us of how central this tool of punishment is in the kingdom. Also in Singapore, no executions for drugs or for other offenses took place for the second year in a row. However, we cannot ignore that 4 notices of executions were issued in 4 months between November 2020 and February 2021. All people whose execution was announced were people convicted of drug offenses and all living with vulnerabilities or belonging to a marginalized group. As of now, these executions have been paused pending judicial proceedings, but against these people are to be considered at imminent risk of execution. Finally, we recorded a slight increase in drug-related death sentences around the world. We could verify 237 death sentences in 16 countries. However, this likely represents only a fraction of all executions of all death sentences that were imposed. Also because we could not access figures on Iran and Saudi Arabia, nor China, and all the other countries we could verify that sentences for do not provide updated and official information. So what do these figures tell us? First of all, we saw a huge increase in drug-related executions between 2021, a over 300% increase, and this goes against this trend of regular decrease that we had witnessed in previous years. This reminds us that progress is fragile and that comprehensive reforms are needed. Just tinkering with a few bits of law and policy, like it happened in Iran in 2017, is not going to be enough to achieve sustainable and lasting progress. Secondly, the group of countries that actually execute people for drug offenses is becoming smaller and smaller and is more and more isolated from the rest of the international community. At the same time, it's a group that is strongly resistant to reform and abolition, and so targeted engagement is necessary. Finally, I want to note this ubiquitous lack of transparency when not active censorship, coupled with suppression of civic space in retentionist countries, which remains one of the key issues for people working on this phenomenon. We cannot monitor, we cannot evaluate, we cannot change what we don't know. Notably, human rights law requires retentionist countries to be transparent on their use of the death penalty and to regularly publish information, both domestically and internationally. And so fellow member states, as well as UN agencies, including UNODC, have a responsibility to ensure that this obligation is respected. I only want to take one more second to talk about the people that we know are disproportionately or uniquely impacted by the death penalty for drug offenses. As Dr. Morales was mentioning before, one of these groups, many of which experience intersecting forms of vulnerabilities, are foreign nationals. Around 1/10 of all death sentences for drugs confirmed in 2021 were against a foreign national. And this includes all but 1 drug-related death sentences in Egypt, Kuwait, and the Emirates. Ethnic minorities are also uniquely impacted. For example, OHCHR recently denounced a trend of executions against Baloch minority prisoners, mostly for homicide and drug offenses. Another group which is worth highlighting is that of people experiencing mental health issues or intellectual disabilities. This is a population we really don't know enough about, but recent studies, including in India and in Bangladesh, have highlighted how pervasive this issue is on death row. Similarly, in Singapore, all 4 people whose notice of execution was issued in the past 5 months live with, experience some sort of mental health issue or live with an intellectual disability. Unfortunately, independent psychiatric assessments on death row are extremely hard to conduct, so we need more research on the prevalence of this issue on death row, and specifically among people sentenced for drug crimes, and on the potential links between mental health issues and engagement in the drug market. Finally, another group of people which are uniquely impacted or that experience unique vulnerabilities around the death penalty for drugs is that of women. As also detailed in a 2021 report published by the Cornell Center on the Death Penalty Worldwide and HRI. Women, for example, as confirmed by Iran Human Rights, the majority of women executed between 2010 and October 2021 in Iran had been convicted for a drug offense. And also drug offenses are responsible for the overwhelming majority of women on death row in countries such as Thailand and Malaysia. I'll stop here, but I'm happy to answer any question later. Thank you. And back to you, Zaved.
Thank you very much, Giada. It's a really important report. I encourage our colleagues and partners to read the report and reflect on this report, actually. This report, after publication of the report, the key issue is that support from the member state as well as other stakeholders for the implementation of the recommendation. Because we can produce very good report, but if implementation is slow, we are not moving forward. I would like to also mention that last year, 2 reports published by OHCHR from the UN Human Rights System, 1 report by the Secretary General looking at the transparency and death penalty. And that was really, it shows that how the non-having transparency has impacted in the death penalty cases which is related to drug-related offenses, and also on the issue of deterrence. Without further ado, I would like to introduce our next speaker, Mr. Tony Ojoku, Executive Secretary, National Human Rights Commission of Nigeria. Before I'm handing over to him, I would like to highlight one small thing. This is so important to have the National Human Rights institution to be part of this meeting, because all over the world, we know the National Human Rights Commission play a big role to monitoring the situation with regard to death penalty, and even in some countries led the abolition of the death penalty. And with regard to Nigeria, we have information, large number of Nigerian facing death penalty elsewhere outside Nigeria, inside or also outside Nigerian, mainly Nigerian foreign national, and they're being not only just victim of the justice system, but also racism issue. This issue also raised in our recent report by High Commissioner on Racism and Law Enforcement, that how justice system deal with against people of African and African descent. With that note, and now acknowledging the important role played by the National Human Rights Institution in the abolition of death penalty, I would like to invite Tony, the Executive Director, Executive Secretary of the National Human Rights Commission of Nigeria, to speak. Your floor.
Thank you very much, colleagues. And I want to thank Harm Reduction International and their collaborators for organizing this important event and for extending an invitation to the National Human Rights Commission of Nigeria to share its perspectives. NHRC Nigeria wishes to express solidarity with the people of Ukraine, Nigerian students, and other nationals who are facing grave humanitarian crisis, and we urge all well-meaning and enlightened democracies to support Ukraine to ameliorate the humanitarian situation in Ukraine. I would like to start my intervention this morning by affirming our position that life is sacred and can only be taken under circumstances permitted by law. General comment number 36 is very instructive as to the application of death penalty to very serious crimes. As a national human rights institution, we have been deeply worried about the increased application of death penalty and executions to foreign nationals, including Nigerians and the other Africans accused of drug-related offenses in foreign jurisdictions, especially parts of Asia. While not condoning the crime of drug trafficking, our case against death penalty in foreign jurisdictions stem from the following socio-legal premise: absence of fair trial, lack of access to consular assistance, prolonged detention, torture, inhuman and degrading treatment. The right to a fair trial is not only an international human rights standard, it falls under the realm of natural justice. Fair trial refers to a cocktail of rights recognized by international human rights law and national constitutions. These include the International Covenant on Civil and Political Rights, the African Charter on Human and People's Rights, and the 1999 Constitution of the Federal Republic of Nigeria as amended. In some of the foreign jurisdictions where death penalty is applied for drug offenses, the right to fair hearing is hardly recognized or applied. And these include the right to be presumed innocent until proven guilty, the right to be heard by a competent, independent, and impartial tribunal, the right to be tried within a reasonable time, the right to an adequate defense, the right to effective legal counsel of his or her choice, the right to be tried in the language the accused understands, including interpretation and translation, the right to self-determination, the right to freedom from discrimination, and the right to appeal. In addition to the above, from our perspective, accused persons who have been tried and sentenced to death in foreign jurisdictions often lack access to consular assistance and advice. Accused persons also have little or no knowledge of the criminal procedure legislations and other court rules to enable them to prepare and present their case in court. The issue of prolonged detention, torture, inhuman and degrading treatment used in drug offenses are also issues of great concern. Some accused persons have been known to confess to crimes under torture or false promises of lighter sentence. As a national human rights institution, we see our roles in 4 major aspects. Agenda setting. This includes continuously placing the issue of death penalty for drug offenses on the national and global agenda, bringing attention to ongoing human rights violations associated with these practices. Monitoring and reporting. National human rights institutions have important roles to play in monitoring and reporting cases of their nationals awaiting trials and execution in other countries where death penalty is applied for drug offenses. As the National Human Rights Commission, we monitor the conditions of their detention and their awaiting executions. Networking and information sharing. As the National Human Rights Commission, we work with our counterparts across other countries who apply death penalty to share information about detainees, to raise awareness on conditions of trials and detention, and to work with their national authorities on possible alternatives, including commutation of sentences, moratoriums, and other measures. As the National Human Rights Commission, we also work with regional and global bodies such as the Global Alliance for the Network of National Human Rights Institutions and NARI to put pressures on governments of countries that currently still apply death penalty, especially when it relates to Nigerians. We also carry out national advocacy. We use our promotional mandate as a national human rights institution to do frontline advocacy for reforms of laws that applies the death penalty to drug-related offenses. We also continuously advocate for improvement in socioeconomic conditions which deepen vulnerabilities associated with most drug-related crimes. In addition, as a national human rights institution, we work with relevant national agencies and civil society organizations to educate citizens on the consequences of drug offenses, especially in foreign jurisdictions. In conclusion, I would like to urge that states that still apply death penalty for drug offenses add that they have few situations where death penalties have been applied to individuals under mistaken identities or misapplication of laws. Once life has been taken, no amount of remedy can be a replacement. I want to thank you for the opportunity to make our interventions, and I wish all of us successful deliberations. Thank you.
Thank you, Tony. You touched upon really few important issues, particularly with regard to foreign nationals who are facing death penalty, and that in a foreign environment, their situation is really dire situation, we know. And also that international convention, which you mentioned about the Vienna Convention, consular services, which is very critical. In our Secretary General's report, every year we are reporting on this particular issue, and also General Assembly resolution addressing this issue. I think still we have a lot to do on this area, that the migrant workers or other foreign nationals who are facing death penalty outside their own country. With that note, I would like to move to next speaker, Ms. Tiasri Wiandani. She's from the National Commission on Women on Violence Against Women from Indonesia. She will be focusing on the issue of intersectionality between women, drug policy, and death penalty, especially in the context of women migrant workers. And recently, this particular issue has been addressed by civil society as well as United Nations report, including Special Rapporteur and Special Rapporteur on Summary Execution, and also Working Group on Women and Discrimination of the UN, of the Human Rights Council. So this issue is at the center of our discussion in different fora. I think that we can hear from Tiasri, from the Indonesian context, this particular issue. I would like to hand over the floor to her, and the translation service available in Bahasa. Please, Tiasri, over to you.
Terima kasih Bapak Zaved Mahmood memoderasi acara ini. Selamat sore waktu Indonesia. Saya mewakili Komnas Perempuan untuk menyampaikan materi berkaitan dengan situasi hukuman mati, narkotika, TPPO, dan perempuan pekerja migran. Sebelum ke materi, ingin saya sampaikan bahwa Lembaga Komisi Nasional Anti Kekerasan Terhadap Perempuan atau biasa disebut dengan Komnas Perempuan itu berdiri sejak 15 Oktober 1998. Next. Komnas Perempuan lahir dari tragedi Mei 1998 yang dilandasi pada keputusan Presiden nomor 181 tahun 1998 dan dikuatkan dengan perubahan landasan yaitu Perpres nomor 65 tahun 2005. Sebagai lembaga nasional hak asasi manusia yang independen, Komnas Perempuan bukan bagian dari eksekutif, legislatif, dan yudikatif, dan landasan kerjanya adalah Undang-Undang Dasar 1945 sebagai landasan konstitusi, Undang-Undang Nomor 39 Tahun 1999 tentang HAM, Undang-Undang Nomor 7 Tahun 1984 tentang ratifikasi SEDO, Undang-Undang Nomor 5 Tahun 1998 tentang ratifikasi CAT, dan program prioritas Komnas Perempuan di 2020 sampai dengan 2024. Pertama adalah kekerasan seksual, keempat perempuan pekerja, kelima penguatan institusi. Untuk isu TPPO, hukuman mati dan interseksionalitasnya dengan narkotika bagi perempuan pekerja migran ini masuk ke dalam isu perempuan pekerja. Next. Tujuan dari Komnas Perempuan mengembangkan kondisi yang kondusif bagi penghapusan segala bentuk kekerasan terhadap perempuan dan pemenuhan hak asasi perempuan, serta meningkatkan upaya pencegahan dan penanggulangan segala bentuk kekerasan terhadap perempuan dan perlindungan hak asasi perempuan. Mandatnya adalah menyebarluaskan pemahaman publik, melaksanakan pengkajian dan penelitian, melakukan pemantauan, pencarian fakta, dan pendokumentasian kekerasan terhadap perempuan, memberikan rekomendasi dan melakukan tinjau ulang atas produk hukum dan peraturan, serta mengembangkan kerjasama atau kemitraan baik nasional, regional, dan internasional. Next. Ini cara kerjanya, kami tidak memiliki kantor perwakilan dengan mekanisme unit pengaduan untuk rujukan di dalam merespon pengaduan dari korban dan pendamping. Next. Ini jajaran kami di Komisioner Komnas Perempuan 2024 sampai dengan 2020 sampai dengan 2024. Next. Kami mengambil isu besarnya adalah perlindungan perempuan pekerja migran dikaitkan dengan tema diskusi interseksionalitas antara perempuan, kebijakan narkoba, dan hukuman mati, terutama dalam konteks perempuan pekerja migran. Next. Ketika bicara tentang isu yang diminta, kita pasti akan berlandaskan pada hak asasi manusia sebagai landasan yang sangat fundamental, bagaimana HAM itu berlaku secara universal, dan ketika bicara tentang hak asasi perempuan di Indonesia itu masih terjadi kasus-kasus pelanggaran hak asasi perempuan. Nah, yang sering terjadi adalah kekerasan berbasis gender, kekerasan seksual yang dimana juga menjadi salah satu bagian dari kekerasan berbasis gender, ada diskriminasi berdasarkan orientasi seksual dan identitas gender, diskriminasi di tempat kerja, serta pelanggaran pemenuhan hak konstitusi warga negara. Next. Nah, di Indonesia sendiri kasus TPPO juga masih sangat tinggi, dan kita tahu bahwa TPPO juga sudah ditetapkan sebagai kejahatan kemanusiaan seperti tertuang dalam Statu Roma, dan ini menegaskan bagaimana TPPO sebagai kejahatan terhadap kemanusiaan, dan Indonesia sendiri sudah memiliki payung hukum yaitu Undang-Undang Nomor 21 Tahun 2007 tentang pemberantasan tindak perdagangan orang. Next. Kami melihat dari fakta-fakta kasus yang terjadi dan dari beberapa pengaduan yang diterima oleh Komnas Perempuan, modus-modus TPPO adalah antara lain pengantin pesanan, pemberian beasiswa di luar negeri, iming-iming bekerja di luar negeri dengan gaji besar, pemberangkatan korban dengan penyalahgunaan visa, serta pemberangkatan korban dengan dokumen palsu. Next. Kasus PMI pengaduan ke Komnas Perempuan sejak tahun 2019 sampai dengan 2021 terus mengalami peningkatan. Ini berkaitan dengan trafficking, pelanggaran hak pekerja migran, serta bagaimana pekerja migran yang harus berhadapan dengan hukuman mati. Nah, ketika bicara tentang pekerja migran yang berhadapan dengan hukuman mati, advokasi yang dilakukan tidak hanya pekerja migran Indonesia yang berada di luar negeri, tetapi pekerja migran warga negara asing yang masuk ke dalam wilayah Indonesia karena terjerat kasus narkoba, karena menjadi korban TPPO, itu juga menjadi fokus advokasinya Komnas Perempuan bersama jaringan masyarakat sipil, karena kita melihat kasus-kasus TPPO itu rentan menyasar perempuan pekerja migran yang ini juga merentankan mereka harus berhadapan dengan hukum yang berujung pada kasus terpidana mati. Next. Kami melihat ada lingkar setan kemiskinan dan KDRT, antara lain adalah feminisasi kemiskinan, keterbatasan lapangan pekerjaan, akses pendidikan yang terbatas, perkawinan anak, serta lingkar kekerasan dalam rumah tangga, yang menjadi salah satu alasan perempuan memilih mencari pekerjaan ke luar negeri, termasuk mereka yang akhirnya berhadapan dengan hukuman mati. Next. Nah, ini kondisi kerja yang eksploitatif dan tidak manusiawi yang kami dapatkan dari proses pengaduan dan fakta-fakta yang kami temukan. Ada bentuk-bentuk kekerasan yang terjadi, yaitu kekerasan fisik, kekerasan psikis, kekerasan seksual, kekerasan ekonomi, TPPO untuk eksploitasi kurir narkotika. Ini sering terjadi dengan penipuan, janji pekerjaan lebih baik, janji menaikkan dan dijebak menjadi anggota sindikat narkotika. Juga ada ancaman pembunuhan, dipaksa menyelundupkan narkotika di bawah ancaman pembunuhan pada dirinya dan keluarganya. Kasus-kasus ini yang kami dapatkan dari fakta-fakta yang disampaikan baik korban ataupun lembaga pendamping yang mendampingi kasus tersebut. Next. Kita ketika bicara tentang kekerasan, maka ada dampak kekerasan yang terjadi. Nah, dikaitkan dengan interseksionalitas kasus TPPO, narkotika, dan hukuman mati, maka ini juga dampak kekerasan yang dialami oleh perempuan korban, antara lain dampak secara ekonomi, dampak secara seksual, mental, dan fisik. Next. Nah, kami juga melihat bagaimana pidana mati sebagai situasi puncak tertinggi diskriminasi dan kekerasan berbasis gender terhadap perempuan, di mana kemiskinan dan KDRT berdampak pada proses migrasi ke luar negeri, dan akhirnya merentankan perempuan pekerja migran ataupun calon pekerja migran dalam kondisi kerja yang tidak manusiawi, dan juga situasi di mana terbatasnya akses keadilan yang akhirnya berujung pada kasus hukum menjadi berhadapan dengan kasus terpidana mati. Nah, dari kasus yang kami terima itu ada mereka yang terpidana mati karena membela diri atau agresi karena kasus kekerasan yang dialami atau kasus eksploitasi tenaga, praktek serupa perbudakan yang dialami. Nah, ada juga dieksploitasi untuk penyelundupan narkotika. Next. Nah, Komnas Perempuan menerima pengaduan dan memantau kasus hukuman mati yang terjadi dalam negeri maupun perempuan pekerja migran Indonesia di luar negeri, dilakukan oleh gugus pekerja migran. Itu di tahun 2016 kami menemukan bagaimana kematian berulang, perjuangan perempuan pekerja migran terpidana mati dan keluarganya merebut hak hidup, serta kekerasan terhadap perempuan dalam pusaran migrasi, perdagangan manusia dan narkoba, interseksi dan penghukuman itu pada tahun 2018. Next. Nah, ini dua potret perempuan terpidana mati, korban dari sindikat TPPO, keduanya juga merupakan korban dari KDRT, yang di mana kasusnya masih berlanjut. Untuk Ibu MGP adalah warga negara Filipina yang terkena putusan terpidana mati di Indonesia karena membawa narkotika, dan Ibu Mary Utami juga karena membawa narkotika. Next. Sedikit lagi, ini tantangan yang dihadapi di Indonesia berkaitan dengan kesetaraan gender di Indonesia dan penghapusan KTP. Selanjutnya, next. Nah, upaya pencegahan TPPO yang dilakukan oleh Komnas Perempuan bersama jaringan masyarakat sipil, di mana juga kasus TPPO sangat erat irisannya dengan kasus-kasus hukuman mati, maka kita mendorong pelaksanaan Undang-Undang Perlindungan Pekerja Migran, serta mendorong Indonesia agar melaksanakan beberapa konven internasional, dan pemeran pemerintah daerah dan pusat itu semakin menguatkan upaya untuk pemenuhan perlindungan bagi perempuan pekerja migran, penghapusan kekerasan, dan penghapusan hukuman mati. Next. Nah, rekomendasi Komnas Perempuan ini kami sampaikan kepada pemerintah untuk mendorong bagaimana upaya pemenuhan perlindungan dan upaya penghapusan hukuman mati bagi mereka, kelompok-kelompok rentan yang berada dalam situasi kerentanan, harus berhadapan dengan hukuman mati, berhadapan dengan kasus-kasus TPPO, dan berhadapan dengan situasi migrasi yang tidak aman dan tidak ramah bagi perempuan serta kelompok rentan lainnya. Nah, rekomendasi ini selalu kita sampaikan di berbagai upaya advokasi, bertujuan goal tertingginya adalah Indonesia melakukan penghapusan hukuman mati di dalam produk hukum domestik. Demikian paparan dari saya, nanti bisa diperdalam dalam sesi diskusi. Terima kasih.
Thank you very much, Ms. Wiandani. And it was really important to hear from you this intersectionality between women, drug policy, and death penalty, particularly one issue which you have mentioned, the impact of the how the poverty play a role into all this. We know that all over the world, not only Indonesia, all over the world, that the poorest, the poor, they are the victim of the death penalty because of the justice system, the way it is formulated. And this link, poverty and use of the death penalty is really important. And different reports from the UN Human Rights Office also looked at it. And I think we need more evidence like the evidence you have provided today to us. with that note, I would like to move to our next speaker. We are running a little bit late, but I hope that we'll keep it short. Sarah Farouk from the Justice Project Pakistan. She's lead of the legal team. She will be presenting the Justice Project Pakistan conducted research recently on foreign nationals sentenced to death, and what are the lessons learned from that process. And obviously, just this kind of evidence to bring up and give a service, put it on the table is so important to understand the situation. So I would like to welcome Sarah to present your research. Sarah, over to you.
Thank you so much. First of all, I would like to thank the esteemed moderator and the organizers for giving us this opportunity. I'm Sana Farrukh. I currently lead the litigation team at Justice Project Pakistan, and I will be presenting some of our work on this area. JPP is a pro bono law firm, and it represents the most vulnerable Pakistani prisoners facing the harshest punishments both at home and abroad. We take an interdisciplinary approach to these issues. Led by lawyers and investigators, our legal team carries out strategic litigation, pursuing cases on behalf of individuals with the potential to bring systemic change. Our communications team devises rigorous media campaigns and public events directed towards changing the public perception about the death penalty. And fierce domestic and international advocacy campaigns with the potential to bring systemic change are carried out by our advocacy team. To understand the issue of Pakistanis on death row around the globe, it's important to have some context on what this diaspora means for our country. There are about 9 million Pakistanis working in countries around the globe, and 96% of these migrant workers are located in just 6 Gulf cooperation countries. And more interestingly, about 90% are based in just the Kingdom of Saudi Arabia, in the UAE and Oman. As of June 2021, according to government statistics, there are also reportedly 15,000 Pakistanis languishing in jails across the globe. 88 of them are on death row currently. And out of this 88, 40 are on death row in the Kingdom of Saudi Arabia. And this is a very alarming situation based on the mass execution that has recently taken place. Gulf countries are the largest jailers of Pakistanis. Most people are arrested for non-lethal crimes such as drug trafficking, theft, violation of immigration laws. And Saudi Arabia also remains the largest executioner of Pakistanis for non-fatal crimes. Every 9 out of 10 Pakistanis executed in Saudi Arabia between 2016 and 2019 were convicted for carrying narcotics into the kingdom. And it's important to see that on one end, the government of Pakistan is also encouraging these migrant workers to seek work abroad because they are the backbone of the economy. In the previous fiscal year, 9.94% of our GDP came from remittances from these countries. And we're set to surpass that already, because in the first half of the current fiscal year, remittances by migrant workers made up about nearly $16 billion US. And almost half of this came from the Kingdom of Saudi Arabia and the UAE alone. So the government, on the one hand, is really encouraging people to seek work abroad. But once they get there, there's a severe lack of support provided to them. So on the end of Pakistanis deciding to migrate, there are critical gaps in regulation or of regular migration. So based on that, the lack of the enforcement of protection mechanisms and the lack of a consular protection policy that would cover the briefing of migrants before they actually travel, they end up entrapped often for drug offenses overseas. Once they reach the host country, the lack of consular services become much more apparent, and especially in cases of death row, the consular services Pakistan is able to offer at this time are limited for in situations where the person does end up on death row. There's lengthy pretrial detention, confessions under torture, proceedings in foreign languages without translators, trafficking, and lack of legal representation. All of these issues were identified by us in our previous research and things we're exploring in our current research. And we see a lot of this mimicked in the conditions of foreign nationals who are currently languishing in Pakistani jails as well. So I'd like to take a minute to talk about this too. While Pakistan is not executing for drug offenses, there are still 1,117 foreign prisoners in Pakistan at this time. This is a 2018 statistic, and the lack of information is also worrying for us, and it's hard for us to collect this information as it's a politically sensitive topic. The majority of these foreign prisoners belong to India, Bangladesh, and Afghanistan. Many report that they have never been visited by a consular officer due to, well, citing security conditions. Harsher prison rules apply to these foreign nationals. And I'd like to focus a little bit about some key issues within Pakistan, which is one, the lack of coordination between the relevant ministries, which results in these prisoners falling through the cracks, and also delays in convening of the meetings of the Federal Review Board, which decides the fate of these foreign prisoners in the cases of delayed repatriation. I just have one final point to make about what strategies have worked in the past and what strategies we are currently enlisting. We use strategic litigation to help the government appreciate what their duties are under our constitutional law and the Vienna Convention on Consular Relations. So Article 4 of the Pakistani Constitution speaks about a due process and places a positive duty on the government of Pakistan to ensure that due process, no matter where the prisoner is located. So by using strategic litigation, we are asking the government to make representations on behalf of our clients who are trapped on death row overseas. We also encourage the signing of prison transfer agreements, and that advocacy has resulted finally in a really important document being signed between Pakistan and the Kingdom of Saudi Arabia. And we're hoping we'll see a lot of repatriations under that agreement. We also take advantage of the broad political support for migrants working overseas because they are the backbone of the country's economy. So we use the Overseas Committee, the Committee on Foreign Relations, and keep in touch with the parliamentarians and consistently keep them abreast of important issues so that they can use best practices that we see around the world and hopefully also pass a consular protection policy in the near future. I will stop here, but I would love to answer any further questions. Yeah.
Thank you very much, Sarah, for your presentation. And it is so important that civil society play a role, even using different tools, like, as you mentioned, strategic litigation, and engaging with other different part of the government to address the issue of foreign national or your own national facing death penalty somewhere else. I see that we have now a few minutes before closing remarks for question and answer. I think I would like to do one thing. I have seen the two questions came up in our on the screen. I would like to request our colleague Azam that if you would like to present the questions, and then maybe speakers, maybe panelists, they could respond very briefly. So Azam, over to you.
Sure. Thank you, Zaved. I'm just going to read out a question there are two questions. The first one is on the question is, in addition to the death penalty being used for drug offenses, what data is there on the number of drug-related extrajudicial killings and death in custody of people detained for drug offenses? I'm not sure who, maybe Giada could answer this one, but other speakers, please do share your thoughts and answers as well if you have. And then the next question from Caroline is, consular officials from abolitionist countries in Malaysia have told that it is easier for them to work on behalf of their citizens exposed to capital punishment than consular officials from retentionist countries. Does retention and use of the death penalty in Nigeria make it difficult for the Nigerian Human Rights Commission to challenge the lack of access to fair trials and inadequate consular services for Nigerian citizens in other jurisdictions, such as in Southeast Asia? This could probably a question for Tony. So speakers, please, over to you.
Giada?
Thank you, Ajeng. And yeah, I'll briefly address the first question, but it would be great then if Tonya could answer the second one and if anyone else wants to come in. With regards to extrajudicial killings and that if in custody, briefly, yes, they are a huge issue, not only retentionist countries, but all over the world. And one on which is really hard to gather information simply because while the death penalty is a phenomenon that occurs within the remits of the law, and so sometimes we find official information or information that can be verified AJKs, and that's in custody are essentially abuses of law and violations of fundamental rights, and so it's even harder to gather information on that. That said, we know of trends in certain countries where extrajudicial killings are a systemic and systematic occurrence in the context of drug control. There isn't time to go through all of them, but just to mention some, and there are OHCHR reports on all of these situations. One, which is possibly the most infamous now, is that of the Philippines. Between 2016, when President Duterte took office, and now the Philippines government in itself has acknowledged over 5,000 AJKs in the context of the war on drugs. Civil society and the OHCHR points to at least 8,000 deaths, and civil society talks about over 30,000 people killed on the streets in the context of drug control operations, including of children. We have a significant number of people killed on the street or by law enforcement in custody in Sri Lanka as well. And Ambika Satkunanathan recently wrote a report together with OHCHR, which we can put in the chat, highlighting this sort of trend, which is also reported by OHCHR in 2021. Another situation is that of Bangladesh, where RAB has been responsible for hundreds of deaths of people accused of drug trafficking. And then there are other situations, including that of Mexico, for example. So both countries where the death penalty is in place and countries where the death penalty is not currently part of domestic law.
Thank you.
I don't know.
Thank you, Giada. That's comprehensive, not comprehensive, but you try to give a few information. And it's important to note also that one country now under International Criminal Code for investigation that you mentioned about the Philippine situation, the International Criminal Code now investigating that all this extrajudicial killing and as well as other crimes against humanity with regard to war on drugs. I would like to take this opportunity to announce one event we are having tomorrow at 1 o'clock. Exactly looking at this issue, killing, war on drugs and killing. This aspect tomorrow at 1 o'clock. Maybe you would like to join to get more information. We will have colleagues speaking from Brazil, from Bangladesh situation, Philippine commissioner. So you will have more information. It is related to topic, that one. Now, on the second question on the National Human Rights Commission advocacy with regard to being a retentionist country and doing advocacy, try to do advocacy in another retentionist country for death row prisoners on that issue. Mr. Tony, if you'd like to reflect on something. Your views on that, with what kind of problem you do face.
Yes, thank you very much for the opportunity once more to share my perspectives on this. Now, of course, for retentionist countries, they believe in death penalty. That is part of their national law. And then so if you are going to carry out advocacy, for example, Nigerian nationals that are in other countries, under the Constitution of Nigeria, death penalty is allowed. But the point is, for drug-related offenses, it does no longer carry death penalty in Nigeria. So most nationals who leave Nigeria are not aware that the country they are visiting carries death penalty for drug-related offenses, of course. And these are challenges which migrants have. At times, most migrants don't have all the relevant information they need before they embark on migration. So it is a moral issue, because if you are a retentionist country and your national is in a country and is now convicted and for death penalty, and you are now liaising with the National Human Rights Commission of that country and pleading for your nationals not to be executed, they will be asking you, but in your own country too, death penalty is also allowed. Now, the point is, death penalty in a country like ours, you know, if you are facing any offense that carries death penalty, you are given maximum access to justice. You are given every assistance you need to be able to defend yourself. If you cannot afford a lawyer, there is a legal aid council that is automatically, if once it is an offense that carries the penalty, the legal aid council must give you legal services, and you cannot be executed until you have exhausted all your appeal. That is from the court of first instance to the court of appeal and to the Supreme Court. You know, even after that, you know, there is a moratorium for execution of death penalty in Nigeria, you know, which to a very large extent we hold very, very sacred now. So is a moral issue that you come to my own country and you say I shouldn't carry out death penalty, but it is allowed in your country. So this is one of the challenges we have when we approach our own sister national human rights institutions in other countries. That question comes there, but in your own country too, death penalty is allowed. But like I said, even if death penalty is allowed, for a foreign national, you are handicapped. First of all, you may not even have the resources to hire lawyers. Secondly, the embassies in those countries may not offer effective consular services due to also local challenges in those countries. So the foreign nationals are having a double kind of vulnerability, you know, in that they are not within where they are going to be given maximum access to justice, and those who can assist them are also handicapped. And those who can plead for them are already feeling that, you know, in your own country, you have death penalty. So why will you come here and tell us that we should not apply death penalty? But if it is an abolitionist country, it is easier. It is easier because your philosophy and your advocacy is in line with their general thinking about death penalty. But I think we should push generally that let there, at least, even if there's death penalty, let there be a moratorium on executions, and access to justice automatically to the fullest blast of it should be given to those who face death penalty, so that they have all the possibilities, all the opportunities to be able to put their case.
Thank you very much for your response to this critical question from Professor Karen Hall. Just before I hand over to our last speaker, for the closing remarks, I would like to mention again thanks to all panelists to participate this event. And from my side, I would like to mention one thing: death penalty is not only the undermining the human dignity, right to life, and all other human rights, related human rights, and it is absolute just inconsistent and now the international practice to moving forward for the full abolition of death penalty. And also from practical point of view as well, that in the Angus outcome document, all member state Angus outcome document is that on the special session on world drug problem, the all member state agreed to have a proportionality, promoting the principle of proportionality. Death penalty is not respecting that commitment. That we need to also highlight in addition to our human rights arguments, as well as there is a practical aspect of that abolitionist countries' obligation not to cooperate with retentionist countries with regard to any offenses if this ended up death penalty. So definitely there is also retentionist countries need to understand that to addressing the drug problem or any other serious transnational organized problems, they need cooperation from the abolitionist countries. And if they continue the death penalty, that could be problem to receive those support. Even a special rapporteur on summary execution indicated that abolitionist countries' support could be considered as a complicit to that execution. So those aspects, I think we need to also take into consideration. With that note, I would like to invite our next speaker, Madam Kate Mead from the Australian Permanent Mission here, one of the abolitionist country in the world, promoting abolition of death penalty all over the world. Kate, over to you.
Thank you very much, Zaved. I want to start by saying what a great privilege it is for me to be delivering these closing remarks on behalf of the Australian government. Before coming to Vienna, I worked very closely on Australia's strategy for global abolition of the death penalty and cooperated with colleagues from the other sponsoring states, Austria, Mexico, New Zealand, the United Kingdom, and members of the European Union to promote a world that is free of this most inhuman punishment through the Human Rights Council in Geneva. Australia's position is very simple. Australia opposes the death penalty in all circumstances for all people. We are committed to pursuing global abolition of the death penalty and to supporting civil society, national human rights institutions and others in their efforts to encourage states which still retain the death penalty to abolish it, or at the very least to limit their use of the death penalty as a step towards eventual abolition. Events like this one are so important to raise the profile of this issue and to demonstrate how manifestly unfair, ineffective and inappropriate the death penalty is as a response to drug-related offences. We welcome the messages we've heard today that amplify the disproportionate impact of the death penalty on foreign nationals, women and other individuals in vulnerable situations. I'd like to thank all the speakers today for their insights and hope that this further galvanises us all to act on this important issue. I can assure you of Australia's support. Thank you.
Thank you very much. With that note, on behalf of all co-organizers of this event, I'd like to again thank speakers and also participants of this event from all over the world who have participated. And I hope that you're taking this message that death penalty doesn't have any place in the world in the 21st century, and we have to work towards that, to abolition, universal abolition of the death penalty. We need to mobilize our efforts and continue working together on that. Thank you very much.
Thank you very much, everyone. Thanks for the speakers and thanks for the participants as well.
Yeah, bye-bye.
Thank you.